Good afternoon, gentlemen. Hope you're doing well today. Let's get started on a review of the case law for this week.
All right. My case was Gilligan, Gooding, Batzel, and Anderson versus Condor Aerial LLC. And this case is out of the first DCA. It started out as a breach of contract case, and at some point during the course of the litigation, the plaintiff accused the defendant of destroying evidence. And the court doesn't go into great detail on it, but I think it had something to do with the defendant's counsel. So the defendant's counsel was a rather large law firm, and they actually had a CEO. That CEO was testifying, and over the course of the testimony, questions were asked as to the CEO's past criminal behavior. They attempted to impeach the CEO by asking the court to take judicial notice of an unpublished Georgia opinion, which the court refused to do. They asked this on multiple occasions, and they even sought the judicial notice after the hearing, which the court ultimately denied. The interesting thing about this case, which I thought was pretty random, was after the fact, they then sought 57105 sanctions, citing the fact that it was an improper attempt to seek judicial notice, and it was a waste of everybody's time. The court actually entertained this motion, and then it actually granted the motion and awarded 57105 fees. 2 years later, after it went up on the first DCA reversed and said this wasn't proper. And I only bring this up because a 57105 motion and letter is something that we often like to do or we are faced with. And oftentimes I don't think that I've ever actually sat back and looked at whether or not what I've been threatened with was sufficient under the statute. And what the court did was it went in and it looked at the plain language of the statute and said, what is it for? It's for an improper claim or defense that is devoid of legal merit. And they said, quite frankly, whether or not it was proper to seek judicial notice has no relation to 57105 because it's not under the statute. Therefore, you can't seek sanctions, and the sanctions were improper. And that was my case. I thought we could definitely use that in the future. So thank you.
Good afternoon. The case I've been reviewing is Hunter versus Catalano. It is actually an appeal from our judicial circuit. A decision rendered by Judge Hayes that was appealed to the Second District Court of Appeal. And essentially it dealt with an interpretation of Florida statute section 720.311, which is part of the chapter governing homeowners associations. Essentially, the Catalanos made changes to their property that adversely affected the Hunters' property. So the Hunters then filed a 3-count complaint, which included various different violations of the homeowners association declaration, and also essentially alternatively violations of the statute that governs homeowners associations and those declarations being chapter Florida statute section 720.311. Well, under Florida statute section 720.311, that typically requires a pre-suit requirement of mediation if there is a dispute between a homeowner and the homeowners association. So essentially the court construed that requirement against the homeowner and said, look, there is a pre-suit mediation requirement. This was pursuant to the Catalanos' motion to dismiss. And so the motion to dismiss was granted and the case was dismissed without prejudice. Now, even though it was granted without prejudice, at that point, the moving party that had prevailed would be entitled to their prevailing party attorney's fees under Florida statute section 720.311, and that's exactly what they did. They moved to for enforcement of their attorney's fees as the prevailing party now that their motion to dismiss was granted, even though it was granted without prejudice. And that forced the Hunters to appeal to the Second District Court of Appeal. Well, the Second District Court of Appeal did reverse Judge Hayes's decision and found that essentially 720.311, though it does require pre-suit mediations in some limited circumstances, it's very important to determine who the parties are that are required to attend that pre-suit mediation. So while there is a pre-suit mediation requirement, with a homeowners association acting in its capacity as a homeowners association and with a homeowner. As between two homeowners, the statute does not include that requirement. So essentially, and I think the Second District Court of Appeal was correct in its decision, because essentially it said, look, if the statute wanted this to be between the homeowners, it clearly could have included that language. But instead, by specifically saying this pre-suit mediation requirement is going to only apply between a homeowners association and the homeowner, that means that it does not apply between two homeowners. So even if two homeowners are seeking relief pursuant to the statute, that doesn't mean they're not acting in the capacity of the homeowners association. And so that pre-suit requirement under Florida statute section 720.311 is not going to apply to them. I thought that was interesting, and also thought it was interesting that they would have appealed an order without prejudice, but as discussed, there was already an adverse impact to them because they essentially, there wasn't a motion at that point, pending against them for losing even without prejudice, because now they were the moving party on the motion to dismiss, was now the prevailing party for purposes of their attorney's fees. So interesting things to consider, especially when dealing with Florida statute section 720.311.
So would you say, like, what about a situation in which a homeowner is bringing an action for violation of one of the restrictive covenants, and is essentially standing in the shoes of the association? I've seen, both in the statute and in certain association documents, language that gives the homeowner the right to essentially enforce the docs. Is that the kind of case this was?
Essentially, it was for declaratory relief and for breaches of the declaration.
So that's effectively.
Yeah, and I think a lot of it will depend on how it's titled. If you are actually, if you're the parties actually finding yourself, for example, having an assigned, I could see a situation perhaps where you were getting assigned the claim and you were actually standing legally in the shoes of the association. Maybe it might more likely apply. But in a situation where essentially you're using the homeowners association declaration for your own personal violation, they're just saying 720.311, that pre-suit requirement is not going to apply to you.
Cool, thank you. That's an interesting one. Dan, how you doing?
Good afternoon. All right, so I found an interesting case. It's a Supreme Court case issued on February 4th of this year. It's about what happens when there's some daylight between the lawyer and the client in terms of how to approach a trial. So it's based off of a federal Supreme Court case that came out in 2018 called McCoy v. Louisiana. And it was just a standard murder case there. And the client, against all reason, did not want to admit guilt to anything. There was an overwhelming amount of evidence. And the lawyer in that situation was like, you do not, admit to guilt at the guilt phase. And once we get to the sentencing phase, then the jury's not going to have, any mercy, right? I'm not going to be able to argue for anything against the death penalty. And the client absolutely refused. And the lawyer did it anyhow. Now, an earlier case, a Nixon case, basically says when counsel confers with the defendant and the defendant remains silent, neither approving nor protesting counsel's proposed concession strategy, there's no blanket rule that demands the defendant's explicit consent to the implementation. What happened in this case in McCoy was that the client was very vocal, both on the record, multiple times, Nelson hearings, tried to get off the attorney office case. The judge refused. And then the lawyer went ahead anyhow with a strategy, basically saying he was guilty. Of course he was guilty. The state proved their case, but don't kill him, in other words, right? Now, it's an issue that I've run into before, because in a criminal context, a lot of the times you do want to admit guilt to certain lesser includeds because you want to preserve the credibility to argue for something larger. So if you have like a larger charge, but you think that you can get the lesser included, then it's a very good strategy to go ahead and admit to it and say, listen, we're here to accept responsibility in a limited capacity. All we're asking is that, you find guilty on the things that really didn't happen. You don't have overcharging from the state attorney. You have to get permission from your client to do that. If the client does not give you permission to concede guilt on a point, you cannot concede guilt at any point. But what's really interesting with the Florida Supreme Court case, and that's it's Harvey v. State. It doesn't have a site yet because it was just issued. If the client doesn't object on the record, then the client doesn't have an appeal. Now, that doesn't mean that the attorney is not going to be subject to some bar sanctions. That could still happen. But the attorney doesn't have an appeal unless the attorney voices on the record, I don't agree with this. I completely
You mean the
disagree.
client?
Sorry, the
you
client.
said the attorney, yeah.
Right. The client has to put on the record. There has to be some sort of evidentiary record that the client says, I do not agree with the conceding to guilt at any point at all. If they don't do that, they get no relief. So I thought that was very interesting.
Wow. Did the opinion say anything about what happened to the lawyer with regard to any ethical complaints?
It did not.
That's a gutsy move. That's a gutsy move. When you're going to step up to the plate and some guy who says, no, don't say anything about my guilt, and you're going to step up there and offer that up. I mean, wow, that's more guts than I have.
Especially because my understanding has always been you can't do it, right? You can't argue this guilt on a point that a client hasn't agreed to. And I've asked clients, when I was a public defender, I couldn't willfully withdraw from a case, but I would tell a client, I'm like, listen, I do not agree with your strategy. It's going to be very hard for me to argue that with the passion that you want because it's not something that I believe in. Ask the judge for a Nelson inquiry, see if they'll take me off the case. And so that's happened occasionally. And I think it was best for both of us, both for me and the client.
Do you think that Florida Supreme Court ruling will be subject to review by the U.S. Supreme Court at any level? Do you think it's consistent?
I don't.
I
think it's consistent with McCoy, and I don't think in this case, Mr. Harvey was sentenced to death in '89, so this is like his last appeal after like 7 other appeals. So I don't think anything's coming.
Joe Bear.
Well, good afternoon. My case comes out of a contract for the sale of a business. The parties are Renee Mantella versus Raul Hernandez Fabian, out of the 4th District Court of Appeals. And the plaintiff sued the defendant for fraud in the inducement related to the contract for business for the sale of a business interest. And the trial court granted summary judgment to the defendant based on a release of liability executed at the time of the sale. And I know we've run into these releases or limits on liability from time to time, and it kind of hamstrings the aggrieved party. But in this case, the 4th DCA reversed the trial court's decision, citing the Supreme Court, which the Court of Appeals said the Supreme Court has spoken clearly that no contract provision may preclude rescission on the basis of fraud in the inducement unless the contract provision explicitly states that fraud is not a grounds for rescission of the contract. So I thought it was interesting that not only did they say this release was not effective against the claim for fraud of the inducement, but also even preserve the right of rescission of the contract, which is another issue that I know we've addressed recently. So
the implication is that you can actually have language in a contract that explicitly states that fraud will not be the basis to rescind the contract?
Correct. That's the flip side of the argument. If you're drafting or reviewing contract.
I never knew of such a. Who here doesn't find that surprising? I mean, that's surprising to me.
But it has to be specific. That even fraud.
Yeah. Well,
wow.
I mean, I think we got to put that in if we're ever drafting a contract. Not that we have clients that induce people fraudulently, but that's a pretty good protection, because even if you don't have clients who fraudulently induce people, sometimes we have clients that enter into agreements with people who might claim they did. So
Right, right. So it's an easy protection. You can get your summary judgment if you have that language.
all right, that was a good one. Mr. Scherer?
Well, good afternoon. My case is Extreme Emergency Fire and Water Restoration LLC v. certain underwriters at Lloyd's of London. It comes out of the 3rd District Court of Appeal. It's a recent case, so it doesn't have a reporter citation. It actually deals with an assignment clause, an anti-assignment clause, and an insurance policy. So we do a little bit of property insurance litigation. An assignment occurs often. It's typically called an assignment of benefits. After the loss occurs, a property owner may assign the insurance claim to the contractor who will do the work and then take over collecting payment from the property owner's insurance company. Insurance companies are sometimes not a big fan of assignment of benefits. And so they have tried to put anti-assignment clauses into their policies, but it's been Florida law since about 1971 that post-loss assignments cannot be restricted within an insurance policy. This case, they try to just a creative argument, so it just raises a couple points. So number one, the general rule is post-loss assignment clauses, anti-assignment clauses are not valid. But this case, they tried to make the argument that the anti-assignment clause was actually in the insurance application. And so it wasn't in the policy. So the argument was, well, a policy is a unilateral decision. The insurance company issues the policy, whereas the application, the customer, they argued, negotiated this anti-assignment provision. And so therefore it's distinguishable from an anti-assignment provision in a policy. Court said that's a distinction without a difference. The general rule is anti-assignment clauses are not valid with respect to post-loss assignments. However, the second point of the court raised that I pulled out of the case, it's actually in a footnote, is recently the Florida legislature actually addressed this issue, and there is a particular statute now that does allow insurance companies to have an anti-assignment clause or disallow post-loss assignments, but they have to meet certain statutory requirements in order to do so. And so that statute is 627.7153. And so there's just certain boxes now that they have to check that the legislature has put in place. And so that anti-assignment clause may very well be valid. But little kind of interesting case, kind of interesting nuanced argument, but the court just didn't buy it. But a couple points there on assignment of insurance benefits.
All right. Well, thank you, gentlemen. That was educational and well done. Appreciate it. Until next week.
Thank you.
See you guys.
Thanks.
Yeah.